All right, everybody, Brett Thompson, Thompson Law Group, another installment of the Teaching Tuesday. This one is specifically for real estate agents in the Hampton Roads area pertaining to the RAIN contract, the Real Estate Information Network contract. I've been getting some questions in regards to the deposit, all right? So the EMD, the earnest money deposit that the buyer tenders at the execution of the contract. So in regards to the deposit, this is going to be governed by paragraph 2. And then also paragraph 5 of the RAIN contract. The deposit has to be tendered by the buyer within 2 days of ratification of the contract. So we enter into a contract, within 2 days, the deposit has to be delivered to the escrow agent. The escrow agent could be, for example, this law firm, or it could be a broker, the selling agent or the listing agent. If the buyer fails to tender the earnest money deposit check within 2 days, all right, or the check bounces, both of those would constitute a default under the contract, and the seller could terminate the contract at that point based on the default. Now, in regards to the disposition of the earnest money deposit, so whoever is the escrow agent, so it could be this law firm, a title company, or it could be one of the brokers involved in the transaction. They have to deposit the money within 5 days of the ratification, okay? If they don't get the money within, let's say they get the money prior to the ratification date, they've got 5 days from the ratification date to deposit the money. If the money comes in on day 1 or day 2 after the ratification date, they have 5 days after that date in which to deposit the money. So the buyer has to tender the money within 2 days, and the escrow agent has to deposit the money within the 5 days. If the contract does not come to fruition, okay, it doesn't close for whatever reason, and perhaps one party is in breach. So what do we do? So if this law firm is acting as the escrow agent and we're holding the money, we've got two options basically. Either we're going to wait for an agreed upon termination agreement or a release agreement whereby both parties, the buyer and the seller, have signed and they have agreed to the disposition and the disbursement of the EMD. If they don't agree, the Virginia Code provides for an interpleader, and basically an interpleader is the law firm would pay the money into court and would provide notice to both the buyer and the seller, and the buyer and the seller would have to fuss over the deposit in front of the judge, and then the judge would make the determination on who should get the deposit. All right. If a broker is holding the deposit, the listing agent or the selling agent, there is a provision in the contract that says the broker, if they feel one party is entitled to it based on the clear, concise language of the contract, they can give notice to the other party. For example, if the broker feels that the buyer should get the deposit back, the broker is going to send notice to the seller and the listing agent saying that we are going to disperse the deposit to the buyer. And you have 15 days in which to provide us notice that you are contesting that, all right, and then you object to it. So if within the 15 days after the notice they give you a written objection, then the broker does not have the authority to disperse the money. And the broker may be looking into the same scenario whereby the broker would need to interplead the money into court and let the buyer and the seller fuss over it in front of the judge. But in a nutshell, that's how the deposit works in the RAIN contract. Have a great Tuesday. Thanks.